Hi everyone, it's Carl again with Remax West, and today we have a special guest, Andrew McMaster with Stonegate Legal Services. He's an experienced paralegal who works extensively with the Landlord and Tenant Board. We'll be diving into matters that every home buyer, seller, investor, landlord really needs to know. If you're in the real estate game, this episode is for you. Thank you, Andrew, for joining us today. We really appreciate it.
Thank you, Carl. I'm flattered. I'm happy to be here and happy to answer questions you have.
Awesome. Can you tell us a little bit about yourself, background, and what a paralegal really does within the real estate space?
So, thank you, Carl. Thank you for the question. My name is Andrew McMaster. I'm a paralegal. I've been doing this a little while. I did get my license relatively recently in the beginning of 2023. Now, when it comes to paralegals in real estate, paralegals have a very small role. Legally speaking, paralegals aren't really allowed to give real estate advice or speak on real estate matters. However, things do intersect when it comes to tenancy law, right? Because real estate law and tenancy law are like oil and water. They can exist together, but they will never really mix perfectly because they are distinct.
Right.
Um, Usually relates to the sale of property, which again, I can't give legal advice for, but I can inform people of their rights under the Residential Tenancies Act, which is the body of law that governs the Landlord-Tenant Board, which is the jurisdiction that Stonegate Legal Services almost exclusively works in, like in specifically. And so I would say, uh, the way we support buyers or purchasers or landlords in general is to give them information about what their rights are, what they can and can't do, and what kind of manage the risks associated with having a tenancy and if which way it can go when there are in fact disputes, because they do happen.
Right, right. Awesome. So, do you mind telling us what the essential components of a solid rental agreement are, and like how can investors protect themselves from potential tenant disputes?
Question, Carl. So when you send a notice usually comes before an application of the LTB. There are very particular notices that give rise to particular applications. Like the one that people mostly are familiar with is the N4 notice of non-payment. That is when a tenant owes a fraction of money regarding arrears specifically. Or if a rent increase is provided and it's not honored or paid, that becomes arrears. From the point of view of a paralegal who handles disputes, there are a number of things that are required to accomplish a proper notice, and they fall in line with what an essential component of a solid rental agreement is, which are things like when the rent is paid, how much the rent is paid, um, and any other types of information relating to what is paid and when, because we wanted to have it on the agreement. If there's anything that is just word of mouth between the landlord and tenant or any individuals, it can provide difficulty. That's the first thing we ask. Do you have it in writing? Do you have it on a lease? Another thing that's very important to provide notices are who the tenants are and who the landlords are. Very often, if these aren't clear cut and enshrined in writing, and an Ontario standard lease, ideally, it can cause a lot of problems when it comes to a dispute because you want to say, well, who is the tenant, right? Oh, there's two tenants, or are there three? Who's that third guy? Is he a tenant? Does he pay rent? Why is he there? Can he be there? Things like that arise only, and the idea is you want to have everything as clear as possible to provide these notices. Because if you provide a notice without knowing what the rent is, when the rent is paid, it can actually injure your efforts to bringing an application to the board to end a tenancy on a fault or no fault fashion, which is primarily what I do.
Yeah, I think that's excellent advice. I think investors that are even just starting out, they probably should treat their, um, investor type of journey as a business. And in business, everything should be in writing, right? Just to protect you for sure. That's great advice. So,
Absolutely, absolutely, Carl. I agree.
mhm. So what should investors know about Canadian landlord and tenant laws, and how can they stay compliant while managing rental properties?
Well, first, I'd like to say that paralegals, like in different law licenses, my license is for Ontario particularly. The regulating body that I answer to is the Law Society of Ontario, formerly the Law Society of Upper Canada. Um, the idea is that per province, they actually have different legislation. There can be very similar. sometimes even carbon copy, but technically every province will differ. So you should always look to what your province says because it can differ, including, of course, municipalities have different standards. But at the end of the day, the province is what writes these rules when it comes to disputes. Municipalities have their own standards and their own kind of bylaws that will follow suit. So you best be aware of those things. But when it comes to disputes, they go to the province. And to probably the best way to stop any kind of complaint is you want to maintain your property. Maintaining your property is can be very fickle phrasing because maintaining is different than making it perfect, right? You don't have to roll out the red carpet for your tenancies. Ideally, you want to make it nice to lure people in so they can in fact they can rent your property and be happy and speak well of the tenancy they had so everyone can be happy. Money in exchange for renting the property, right? The idea is that disputes arise disputes arise almost over nothing. We have lots of people who call and they have problems. They think it's a problem, and arguably, it may or may not be something the board would really be able to handle. So jurisdiction is always an issue, and honestly, a lot of these problems may solve itself, but if it doesn't, there'll be a dispute, and that's what you would call us. But I'd like to say that you just want to know generally what you can and can't do, and always err on the side of caution. I just like to mention that the first section of the Residential Tenancies Act, which is again the body of law that governs the Landlord-Tenant Board, which is where I work, the jurisdiction of. I don't work for the board myself. I'm a paralegal there, um, representing private landlords. Is that the board is there to stop um, illegal evictions or unfair evictions, stop illegal rent increases. They're essentially there to hold the door for people who they view as to be possible victims of powerful, wealthy landlords, which we know isn't always the case. There are many small landlords. Actually, most of our clients would be described as such. Just knowing when to err on the side of caution and what you can do, and to know when your tenant asks or claims something, to know kind of where you're standing, at least generally, to know that, well, this is something I should do, or this is something maybe we can talk about. Is it negotiable, or is this something that I need to provide right off the bat?
Very good. And I think it is a very essential point where you mentioned that different provinces might have different ways of going about certain things. And I think that's very important because a lot of my clients in Ontario right now, they're starting to purchase in provinces like Calgary or Alberta rather because of the high prices here in the GTA. So
Understand.
that's very good advice. Yeah. So what are the legal implications of different ownership structures for real estate investments?
So when it comes to, in the case of personal ownership versus, corporation, I know obviously there are many benefits to owning a corporation. I'm sure they're manifold. The idea is that there obviously other tax purposes and other things I can't speak too much on. But when it comes to if it's owned by a person or a corporation, the obligations are almost identical. There are just a couple notices or forms for no fault evictions that you can't accomplish because it's a corporation and not a person who owns it. Now, of course, those proceedings would be very particular. The facts have to be essentially distinguished on the facts. The idea is that every case is different. It's very hard for me to gauge exactly what implications would be in each fact because every case is different. We have cases that are similar, and then the dissimilarities can be brought very easily when you realize that um, they have different results. Sometimes results can vary significantly, especially when it comes to the things I mentioned with no fault evictions, and it can be a little complicated.
Gotcha. Understood. Um, well, I really want to ask this question here. Are there any recent changes or trends in the real estate law that may impact investors, and how should they prepare for these developments?
So, as I mentioned earlier, I don't have a license to comment on real estate law. It's not part of paralegal scope of work.
Right.
I'd be careful if you did have a paralegal speaking on real estate law in particular. I'd be careful because I can tell you they're not necessarily allowed to do that. But it relates to tenancy law and things that relate to the scope of work they're allowed to work on. Like in my case, as a paralegal, residential tenancies, there are absolutely um, uh, uh, ways we can't comment. For example, there is a new section in the Act. It was recently amended, Section 212, where there is something called substantial compliance. It essentially means that if there were errors on notices, that would have them thrown out, and now they you have to make an argument, of course, a legal argument. It's not just they just say, oh, you know what, that's fine. You'd have to make an argument based on what the section says. But there may be a lot less applications thrown out by landlords because of this, because of these small errors.
Mhm.
So if I were to say the kind of trend related to residential tenancies is that things may have gotten just a tiny bit easier. And I will say, for what it's worth, this was brought in by Ford, the recent bill cutting the red tape, I believe was one of the phrasings of the bill. The number escapes me, but it actually came into force last week. But regarding real estate law in general, I'm not exactly certain.
Okay. Very, very interesting. Very good. So, what should investors look for in a property management contract to ensure that they're legally protected and their interests are really safeguarded?
So very often I'm confronted with property management companies that assist the landlord. And because there's a dispute, I have to go to the property management company, look for information to find out to touch base. Because sometimes the landlords don't know, and that's fine. That's okay. That's why they hire the property management companies. But I will say, property management companies, in my humble opinion, are not something you can use to kind of fire and forget, I guess that people will use that phrase. If you do hire a property management company, you don't have to look over them with a fine-tooth comb. But I
Mm.
would always remember that you are the landlord. You will be the one liable if something goes wrong. And a lot of the time, the evidence to use to support or deny any of these allegations will be in the hands of the property management company. So they will be essentially your source of information and or a lack thereof, which maybe could be detrimental and could cost you some money. Again, will be costing you legal fees at some point if the dispute does go to the board. So you should always be involved, at least to a degree, having, maybe every couple of months to meet up with them, having a meeting just so you're aware of what's going on, if there are any issues, are there any foreseen issues that may crop up, as well as the idea that property management companies, just when you, I can't speak on the exact contract to contract, but I can tell you that vetting or obtaining tenants for tenancy is something that property management companies often kind of say that they do very well. And I just be very careful when letting them take care of that because there may be disputes not only with the tenants, but with the property management company. So I just want to, like anything, just to be smart and to know what you're agreeing to, why, what you're paying for, and things of that nature. And again, I tell this from experience because they property management companies have, let's just say, injured some of my clients' claims at the board, not through totally their fault, but just maybe through possible mismanagement or not a total agreement on what exactly they're supposed to be doing and what exactly that relation is to any dispute that crops up.
Mhm. Okay, that's great advice. And many of my clients that are thinking about investing in real estate and renting out a property, uh, their issue oftentimes, what makes them really apprehensive is they think that they won't have any legal grounds of evicting a tenant if they don't pay or anything like that. I just want to briefly talk about that. What is the legal process for evicting a tenant in Ontario, and what steps must a landlord follow to ensure compliance with the law?
So it all depends on what kind of eviction there are, right? Generally, if I could, now this is somewhat formal phrasing by the Residential Tenancies Act, but also informal, just the way we talk about it. There are fault evictions, at fault, and no fault. At fault being, for example, you didn't pay your rent, or you pay consistently late and you're not apologetic and have no means or will to pay on time. Those are very different. They have different thresholds to be met. Now, if usually the most common type of eviction is when people are evicted because they don't pay their rent. The idea is that in order to, in the case of a fault eviction, when people don't pay, you want to make sure that your bookkeeping and your ledgers, if you have it, are as clear and clean as possible. You want to make sure that things are separated. Rent arrears versus utilities versus NSF charges versus you want to make sure these are all categorized. Because you start lumping these numbers together, then it becomes unclear what is paid for and what's not. you need to go to the board and give them an exact dollar amount and justify it. And this justification will come in the form of the board member asking how much rent is and providing a bit of information about that. Now, this can be all longer or shorter depending on how much rent is owed. There are a lot of circumstances where landlords don't really pursue their tenants because they owe rent and they let it slide. I want to let you know that many of these circumstances, depending on the facts, those arrears from in the past can still be collected and brought forth in an N4 notice. Again, whether certain parameters have to be fulfilled, and obviously they could be time barred, but it all depends on the situation. Usually they're not. I want to say that you want your bookkeeping to be perfect when it comes to non-payment. You want to say, I paid this on this day, and you want to say, no, that's not. You have to prove it. And you want to have that information readily available because if the board or the tenant can cast doubt on whether you really are confident you received that money, or if you did and when and what method, that could poke holes in the your claim of non-payment, and things may not end well, but not as favorable as they would be. Now that comes to fault evictions. With no fault evictions in Ontario right now, it is usually the good faith standard. So if you are going to evict a tenant on a no fault method, you'd have to fulfill the good faith standard, and you would essentially have to be questioned by the board and provide them kind of the explanation as to why you're moving in or why the purchaser's moving in or why you're renovating or demolishing it. And you'd have to make that justification to the board because they are holding the gate. They're the only source in Ontario that actually severs tenancies. They are the sole source, and jurisdiction goes there with very small exception in very particular circumstances, which I'm not going to go into. But with no fault, you're looking at a lot more time. Time is not on your side. With at fault evictions, things can be sped up depending on the quantum owing and the landlord's circumstances relating to possible mortgage defaults. But you'd have to air this out and you'd have to essentially provide it to the board, and they would make a discretionary order. And often I've had landlords that are owed quite a bit, but the board says it's not enough. They have that discretion, but you always should have some kind of funds to hold the property for, I want to say 12 months, prefer longer. Because if tenants don't pay and it hurts you that badly, you should arm yourself with some kind of assets to hold on to the property, because the board won't be doing things in an expedited fashion always just because you're suffering and because their rent doesn't cover the mortgage or things of that sort. Like you said earlier, Carl, it's a business, and the board will fall back on that whenever it is convenient for them or the situation.
Okay. Wow, this is excellent advice, especially for first-time real estate investors. What I'm hearing is it's really a wise idea to have some money set aside just in case situations like these arise. Obviously, if you're working with a realtor, or if someone is really vetting the tenant, hopefully situations like this won't arise, but sometimes you never know. So having some funds put aside just in case is a great idea. Even not just with tenant issues, if there's issues with in the property itself, if things break down a bit, it's a good idea to have some funds available for repairs in general. That's a great idea. Um, so, what rights do tenants have during the eviction process, and how can landlords balance their own rights with those of their tenants?
So one thing that landlords have to remember is that if you do anything forceful, if you do anything that you will almost always be labeled the aggressor. When in doubt, they will not go after the landlord, but they're the one in the position of power, which I know is sometimes uncomfortable for people to mention. And that's not always the case because seemingly tenants have quite a bit of power. They have quite a bit of sway. Once they rent your property, now they don't own it legally, but they are in possession of it. And to sever that, there have to be particular legal proceedings that would allow for that. Now, they can be long and drawn out, or they can be quick because things can be consented upon, right? Disputes can be solved in many ways that not in front of the board. The idea is that they do have a lot of rights. They're holding the door on a lot of things. And depending on what landlords may do, what you need to do is you need to put, obviously, emotion as best you can aside. We want to be dispassionate when it comes to these things. These people may owe you money. They may owe you a lot of money, but you have to understand that if you take the law into your own hands, you will never win. It will come back and bite you, and the repercussions could be even more far-ranging. Not often does it happen, at least in my experience, but provincial offenses, which are not, they're quasi-criminal acts, so they're not criminal, kind of like a speeding ticket. That's a quasi-criminal. It's against the law, but it goes to the province, and there's a very particular stream of proceedings. The well, province does it a certain way, a certain act covers it. What I mean to say is that those are more, not that often happen, but you could have a provincial offense against you in addition to the civil action that the tenant can bring against you at the board. So the board does civil actions, whereas there can be provincial offenses that the board does give power to the province to prosecute, but that'll be held actually at provincial court. What I mean to say is that be very careful because you are the person who is supposed to be um, the more well-to-do or resourced person where the responsibilities are more with you than with them. And if you don't do things correctly, you will be the person holding the bag, so to say. They have a lot of rights, and almost a large amount of them cannot be waived, no matter what is signed, no matter what you do. And if they can, it will come down to a probably a somewhat lengthy hearing. That the stakes might not be that high, but it may not end favorably, and that will cost you.
Understood. It sounds like the system holds landlords to a higher standard sometimes.
I would say I agree with that statement. I think that now tenants are held to a standard, but at the end of the day, who's benefiting more, right? That's the kind of the way the board look at it. Now, not everyone is lining their pockets so easily and just with total ease. Oh, I own a pro No, it is a job. It can be a full-time job. It is a lot to take on. And like I said, you have property management companies. You should still be involved because at the end of the day, you will be liable and you'll be your name on that public order. It won't be the property management companies. And they do have a lot more responsibilities, I think. But I think that's always the case. People have a lot more benefit, they should have more responsibility. But of course, there's always a balance, and that balance is very easily affected. And I think right now in Ontario, um, the balance is going one direction, and it's to protect tenants. And I think that won't be changing anytime soon.
Right. Understood. So, what should landlords do if a tenant disputes an eviction notice? And what are the common pitfalls to avoid such cases?
Common pitfall is to um, not be irate, but to not react emotionally. So it is an emotional thing. Absolutely. These things are fraught with emotions on both sides, and that no one can be blamed for something like that. But you don't want them to get the best of you because at the end of the day, like you said, you have, as a landlord, you have more obligations, and there's a reason for that. Um, if they dispute an eviction notice, usually it would mean because it's either no fault or fault. If they dispute a fault eviction, it means a number of things. One, and not to speak ill of these individuals, I know very many tenants are wonderful people who pay their rent and are great, and we need them. Landlords need them in a way, so everyone's happy, equal exchange of value. The idea is that if a tenant disputes a non-payment notice, it means that they think there's a percentage of the time they just don't want to leave because they don't care. And there are that category of people, not to be disparaging, but there are those category of people who don't care and they never will care and they do what they want because their credit, their not persona, but they're them in general. They don't care about their future. They don't care about future prospects. And those individuals are hard to keep. You read their mind, you end up reading your own mind. The other side of people is that no, I did pay that rent. And all it would take is to, well, then show us, prove it. Because we wouldn't be doing this if you did pay us. Because that'd be fraudulent for one. And number two, I'm hiring this guy to go after you, and that's not cheap. And the idea is that we're enforcing this. We wouldn't do it for fun. There would be a dispute, and it could be resolved. The fact that, oh, I didn't pay that. Because I've had tenants who essentially go, oh my goodness, you're right. And they concede, and they either pay it, make a payment plan in front of the board with repercussions, of course, things like that. The idea is you don't want to react too emotionally. You don't want to jump the gun, as they say. You want to do things within the law. Want to do it as straightforward as possible. You don't want to cut corners, but of course, money's involved. It's very tempting to do that. But remember, there will be repercussions if you don't come off as honest as possible and be the better person and say, no, board, this person owes me money. I can show you. And if you do that and you do have what you need to support this, the board will reward you and they will end the tenancy in that regard. Now, when it comes to any no fault notices that are being challenged by tenants, they usually have one of two ways. One of two. One is that they don't believe you and they think it's a lie. Then you'd have to go to the board to dispute that and air it out and show, no, there's no lies here. It's pretty straightforward. This is my story. Or the other part is that I can't leave yet. I don't have time. I don't have money. I don't have time. Those individuals um, often are sorted out at the board as well, because the board will give them time. If you're doing a no fault eviction, time is on your side, and it's always will be on the tenant's side, unfortunately, because if things are delayed, they continue living in the unit. Now, if they don't pay, that's when time is really not on their side, and the board will be gunning for them. So it all depends on what kind of notice, and it depends in what manner they're disputing it, whether it actually have merit or whether it's just something to try to delay because they don't want to think about it. They have to find a new place to rent.
I see. Okay. You mentioned the concept of time in all of this. So how long does it typically take to evict a tenant? And if someone wants to, for example, move into their property, like can that person be in that home still for years? Like how long does it typically take to evict someone?
If you were to provide someone let's just say a no fault notice, something like I'm moving in or I'm demolishing or something like that, there is a notice period. And in the former case I just mentioned, it's 60 days. In the latter, it could be up to 100 days. Again, it's at least. You can give more time. You also can't be in a fixed term lease. So there's a few things you got to remember. Now, when it comes to the board and scheduling, it's a bit of a wild card. I often tell my clients, well, listen, I have a ballpark answer and I can't say for sure because I'll always be made a fool of when it's the opposite. I'll say we're looking at probably roughly 4 or 5 months for a hearing, and then we get it in three, right? And it just depends on the way the board schedules things, and that's not privy to us. We don't know what's scheduled when. It's like theoretically, you could file earlier and get a later hearing date, and you could file later and get an earlier one because the slot opened up just coincidentally. So that kind of stuff is not available to us. The round number I usually give people is on a no fault. Usually you're looking at anywhere from 4 or 5 months, sometimes closer to 6, and it could be adjourned. That's one thing that people have to realize is that the board does just adjudicate a high volume of disputes, which is actually why the board was created to take it away from the courts, because the courts were quite bogged down. They have enough claims already, not involving these landlord-tenant board disputes. The idea is that, or the landlord and tenant disputes, rather, pardon. And you're looking at, yeah, 5, 6 months. And if it's adjourned, you're looking at a couple months more. It all depends on how much time you ask for when it's adjourned. It also depends on if the adjudicator is seized, meaning they have knowledge of what happened and that they will now be hearing the matter when it's now scheduled again, which could elongate how long the hearing is, because that person only has so many hours and they have to do with their own scheduling. And they're actually not usually have a prime role in that. The board schedules it for them. So there's a lot of variables in between. I usually say 5 to 6 months, but it could be longer. And we always remember that on top of that, they'll have to add the time that the board takes to get them to leave, because they won't be immediate, especially no fault evictions. And you also have to think of the time that the sheriff will add, because remember, the landlord tenant board severs tenancies or terminates tenancies. The authority to actually evict someone, to actually knock on the door and say, you are commanded to leave. If you do not, you are trespassing. That authority is almost solely invested in the sheriff's office, which is an arm of the enforcement branch of a court, of a courthouse. And this is opposed to bailiffs, which are private, commercial thing. We don't deal with those. Sheriffs are part of the court. And that will add some time because some jurisdictions have a long wait list. Brampton and Toronto have a very long wait list. We're talking 6 to 8 weeks, even beyond. But it's a mixed bag. If you go to the sheriff's office, you could get them at a good time. They'll let you know. They're very helpful people, and you can ask them 100 questions. I'm sure they'll answer the vast majority of them. Now, when it comes to fault evictions, like things like non-payment especially, if depends on how much they owe. If usually it's 3 to 4 months from filing, and the thing is, if they pay a lot of it, again, that won't affect when it's scheduled because we don't know how much they're going to pay it. They just automatically schedule it, or you would choose depending on the circumstances. If there's an L2 as well, or a different application, you can file at the same time. You're looking at 3 to 4 months, and again, I've had times where a rather large quantum is owing, but there's just too many people in the block and you're not heard and it's adjourned through no fault of the representative or the landlord or even the tenant. if they do show up. It things can be elongated through no one's direct fault, but that's just how it works. Adjournment, there's just a lot of cases to be heard, and there isn't enough time. And in that case, you would just you could convince the board to make an interim order, establishing certain things on the tenant. But it all depends on the situation and what the matter is about.
Right. Perfect. Andrew, we really appreciate this. I think this is really insightful. Our audience, I know will love this as well. So, Andrew, where can our audience find you if they should need your services?
Absolutely. So we have an office here in North York, Toronto, 401 in Victoria Park or Sheppard Avenue East and Victoria Park. We do free consultations. If you go to our website at stonegate.legalservices.ca, you can actually book a free appointment for a consultation between Monday to Friday, between 9 a.m. and I believe it's 2 p.m. We do formal consultations. If you're not tech savvy, you can give us a cold call. We'll let you know if we can serve you right then and there, or whether we can book something you could call back. We do it again, daily free consultations. If you wanted to speak to myself and you wanted to call on behalf of asking for my services in particular, which my colleagues are very soon, you hire us, we hire the whole team. But if you were asking for me, you could just ask for Andrew and say, listen, and just tell them where you saw me myself, and I would accordingly get in touch with you. If you want to mention me by name, that would probably be the best way to get to me. The number is a general number. It's 416-937-2766. If you called that and asked for me, I would get back to you probably before the end of the week, or ideally within a couple of days, if not sooner.
Awesome. And we'll put your contact information at the bottom of this video. Andrew,
Excellent.
once again, we appreciate it. Thank you so much.
No problem. It's a pleasure, Carl. It's always a pleasure. Thank you for having me.
You're very welcome.